Debt collection laws that protect seniors. 1. The rising financial pressure on seniors. Rising prices for food, transportation, and medical care place disproportionate pressure on individuals living on fixed income. Debt collectors often exploit this pressure with persistent calls, letters, and threats of lawsuits. The law provides more protection for seniors than debt collectors are willing to admit. So what does that actually mean? Debt collectors rarely volunteer that seniors' core income streams are legally protected and cannot be taken to satisfy old debts. Understanding these protections shifts the power dynamic immediately. Footnote. This section highlights the economic pressures on seniors and the existence of undisclosed legal protections. 2. Required disclosures from debt collectors. Debt collectors must identify themselves, state that information obtained will be used for collection, disclose the original creditor, state the amount allegedly owed, and provide written notice of the right to dispute the debt. These are the bare minimum legal disclosures. They may sound official and intimidating. That is the point. But understanding the script takes away its power. Debt collectors cannot fabricate claims, inflate authority, or imply consequences that the law does not permit. The formalities they recite are not special, they are mandatory. Footnote. This section outlines what debt collectors are legally required to disclose. 3. The Fair Debt Collection Practices Act. The Fair Debt Collection Practices Act restricts abusive behaviors. They cannot call during prohibited hours, threaten actions they cannot legally take, or imply a lawsuit when none is intended. These rules exist because harassment used to be routine. Debt collectors rely on fear. The law relies on facts. When fear is removed, their leverage collapses. So what does that actually mean? It means many threats only work on those who do not know their rights. Footnote. This section explains the behavioral restrictions imposed by federal law. 4. Protection of Social Security and pensions. Federal law prohibits the garnishment of Social Security benefits for consumer debt. The same applies to pensions, VA benefits, 401ks, and IRAs. These funds are considered essential lifelines, and Congress has shielded them for decades. Debt collectors will never say, "We cannot touch your income." Instead, they imply the opposite. But the truth is blunt, they cannot take it, ever. So what does that actually mean? Seniors often pay debts voluntarily, out of fear, using money that the law already protects. Footnote. This section identifies the complete legal protection of Social Security, pensions, and retirement accounts. 5. Withdrawals from retirement accounts. Using retirement savings to pay unsecured debt is almost always harmful. Once withdrawn, the funds lose their protected status and cannot be replaced. The debt remains, the savings disappear, and the collector wins. The law protects the income, but not the decision to spend it. This is where predatory pressure works. Debt collectors know seniors often sacrifice essential savings simply to avoid conflict. Understanding the law prevents that irreversible loss. Footnote. This section explains why withdrawing protected retirement funds is dangerous and unnecessary. 6. Cease and desist letters. A written cease and desist letter immediately stops a debt collector from calling or sending demand letters. It must be in writing. Once received, contact must cease except for one final notice explaining next steps. This is one of the most powerful tools available, and one of the least known. Verbal demands to stop calling carry no legal force. A written notice does. So what does that actually mean? Silence is available on demand, but only if the request is made formally. Footnote. This section describes how cease and desist letters terminate debt collector communication. 7. Impact of lawsuits against seniors. Debt collectors can sue, but the lawsuit is usually meaningless when the senior's income is fully protected. Winning a judgment does not grant access to Social Security, pensions, VA benefits, or retirement accounts. Collectors rely on the fear of lawsuits, not the outcome. The threat is usually more powerful than the reality. Knowledge flips that dynamic, and the lawsuit becomes an empty gesture rather than a financial crisis. Footnote. This section explains why lawsuits rarely result in actual financial harm to protected seniors. 8. Automatic bank account protections. Federal rules require banks to protect twice the monthly amount of deposited federal benefits from garnishment. This protection applies even if the account contains other funds. Bank tellers may not know the rule, but the garnishment department does. The law recognizes that mixing income sources should not eliminate protection. So what does that actually mean? Seniors often fear that once money hits their account, it becomes vulnerable. It does not. Footnote. This section outlines federal rules protecting bank accounts receiving federal benefits. 9. Fear of losing personal property. States provide exemptions for vehicles, homes, and personal property. Even when equity exceeds the exemption, consumer judgment creditors rarely pursue seizure because the process is expensive, complicated, and often unprofitable. Collectors encourage the belief that property may be taken because fear motivates payment. Reality does not support that fear. Practical barriers stop nearly all attempts at property seizure. Footnote. This section explains why seizure of personal assets almost never occurs in consumer debt cases. 10. How legal assistance helps seniors. Legal support programs exist to ensure seniors understand their rights and stop harassment. Once represented, collectors must communicate through counsel. This immediately reduces fear, confusion, and psychological pressure. The purpose is simple: stability. Seniors deserve peace, not intimidation. Legal support reinforces that their protected income is safe and that harassment can be stopped with one letter. Footnote. This section describes the stabilizing role of legal assistance for seniors facing debt collectors. 11. The hidden interests of debt settlement companies. Debt settlement companies profit by enrolling seniors into payment plans even when no payments are legally required. They rarely disclose income protections. Why would they? Disclosing the truth would eliminate their business model. This is another version of the same problem: those who profit from fear do not reveal the laws that dissolve it. Footnote. This section warns that debt settlement companies often exploit seniors' lack of legal knowledge.